Now, here's where the money enters the equation and where I need your complete attention. This ruling ignited what legal scholars are already calling a nationwide firestorm because it does not resolve a single legal question. It opens dozens of them simultaneously across all 50 state jurisdictions, and every single one of those open legal questions represents a compliance cost, a litigation risk, and a capital repositioning event for every business, every insurer, every municipal government, and every financial market that operates within the affected regulatory sphere. The domestic industry directly implicated by this ruling generates, by conservative estimate, between $60 and $80 billion annually in direct economic activity, with secondary and tertiary market exposure that multiplies that figure several times over. When you introduce supermajority level legal uncertainty into a $60 to $80 billion economic ecosystem, you do not get a ripple, you get a wave. And waves do not ask whether you are ready before they hit. The numbers don't lie. Legal disruption cycles of this magnitude have historically produced sector volatility ranging from 15 to 40% over the 18 to 36-month window following the triggering ruling. If you have money in the market and you have not begun repositioning, you are already behind. Not theoretically behind, actually mathematically measurably behind. Minus, I want you to understand exactly how a legal firestorm transmits from a courtroom in Washington into the economy of your state, your city, your neighborhood, and ultimately your bank account and your investment portfolio. Because this transmission mechanism is invisible to most people, and that invisibility is precisely what makes it so financially dangerous. You cannot defend against what you cannot see. And right now, 50 state legislatures, 50 attorneys general offices, thousands of county governments, and hundreds of thousands of businesses are all responding simultaneously to the same seismic legal shift. And the aggregate cost of those responses is staggering. Here is a transmission chain, step by step, with the numbers attached. Step 1. The ruling drops, and immediately the legal interpretation of existing state statutes becomes uncertain. Businesses that were operating in full compliance yesterday are now potentially exposed today, not because they changed anything, but because the legal standard against which their behavior is measured just changed. Underneath them, their first response is always the same. They hire lawyers, lots of lawyers, and the American legal services market is a $450 billion industry annually, and it grows without exception every time a major federal ruling creates interpretive uncertainty at the state level. The winners in that immediate first wave are the large, diversified legal services firms. That is a data point, not an opinion. Step 2. Insurance markets reprice. Every insurer that carries liability exposure in the affected regulatory sphere has to recalculate their risk models within weeks of a ruling of this magnitude. That repricing almost always moves in one direction. Premiums go up. When premiums go up across an entire industry simultaneously, the businesses that cannot absorb the increase exit the market. The ones that can absorb it gain market share. This is consolidation by legal attrition, and it produces clear winners and clear losers among publicly traded companies in the affected sector. The numbers on this are not ambiguous. Post-McDonald v. Chicago in 2010, insurance premium adjustments in the affected sectors averaged between 12 and 22% within the first 12 months. I expect a comparable or larger adjustment cycle in response to this ruling. Listen to me very carefully, because what just happened inside the Supreme Court of the United States is not a legal story. It is a financial emergency, and the clock on your ability to protect yourself started the moment that 7-2 verdict was announced. 7 justices agreed, only 2 dissented, and in a court that has been fractured and deadlocked on virtually every major issue of the last decade, a 7-2 alignment is not a ruling. It is a sledgehammer. It hits every state simultaneously. It hits every market that touches legal liability, regulatory compliance, and Step 3. Municipal bond markets in the most affected states begin reflecting elevated litigation risk. Cities and counties in states that now face the highest legal exposure see their borrowing costs tick upward. For individual investors with municipal bond exposure in high regulation states, and I am talking specifically about California, New York, Illinois, New Jersey, and Massachusetts, that is a direct, measurable hit to the yield and the security of what you thought was a conservative, safe harbor investment. Stop being a victim. Check your bond exposure. Today, not next week. Today. Step 4. Retail consumer behavior shifts in the affected markets. When legal uncertainty hits an industry, consumer spending in adjacent categories either spikes or contracts sharply, depending on the direction of the ruling. Both directions create trading opportunities for people who understand what they are looking at. Most people do not understand what they are looking at, which is why most people are watching money move around them rather than moving money themselves, minus you're broke and you don't even know it. I do not say that to be cruel. I say it because it is the single most important financial truth I can deliver to you right now, and delivering it in comfortable, palatable language would be a disservice to you and to your family. Your money is positioned for a world that no longer exists as of the moment this 7-2 ruling was announced. The legal framework that undergirded your investment assumptions has changed. The regulatory environment your portfolio is calibrated to has shifted. And if you have not begun the process of recalibrating, you are not standing still. You are falling behind. Because the people who move fast in disruption cycles do not just protect themselves. They grow at the expense of the people who move slowly. I don't care about your feelings. I care about your money. And your money right now is telling a story that should make you deeply uncomfortable. The average American household has approximately $170,000 in nets, investable assets, of which roughly 60% sits in retirement accounts that are passively managed and not being actively repositioned in response to market-moving events like this ruling. That means the average American has approximately $102,000 sitting in accounts that are absorbing the volatility of a legal firestorm without a single defensive adjustment being made on their behalf. $102,000 bleeding quietly while you watch YouTube and feel whatever you feel about the politics of the ruling. Cash is trash, but cash is also not the answer here. Sitting in cash while inflation runs persistently above the yield on your savings product is just a slower version of the same loss. The answer is not safety. The answer is intelligent, deliberate, mathematically grounded repositioning. And that is exactly what I am about to give you. Minus, before I hand you the winner's playbook, let me show you the loser's playbook. Because understanding exactly what the losing majority is about to do is just as valuable as knowing what you should do. The loser's playbook in a legal disruption cycle is depressingly predictable, and I have watched it execute with clockwork precision across every major market-moving legal event of the last 3 decades. It never changes. The actors change, the headline changes, the ruling changes, the behavior does not. The first move in the loser's playbook is paralysis, dressed up as patience. The loser tells himself he is waiting to see how things develop. He tells his spouse they are being cautious. He opens his brokerage app, looks at his positions, feels vaguely anxious, closes the app, and goes back to whatever he was doing before. And while he is doing that, the 18 to 36-month disruption cycle I described is running. Every day of his patience is a day of unrealized repositioning opportunity. The market does not pause for the unprepared. It does not send a courtesy notice. It just moves, and the people who were not positioned correctly absorb the consequence. The second move is emotional misdirection. The loser takes the anger, the anxiety, the discomfort that a ruling like this generates and channels it into consumption rather than strategy. He buys merchandise, he donates to organizations, he attends rallies, he posts on social media, he does everything that makes him feel active and engaged while doing absolutely nothing that protects or grows his financial position. I have seen this pattern destroy more accumulated wealth than any market crash I have ever witnessed, because at least in a crash, the damage is visible and people respond to it. Emotional misdirection is invisible. It feels like action while functioning as stagnation. The third move is diversification theater. The loser shuffles money between funds he does not understand based on headlines he only partially read and calls it adjusting his portfolio. He moves from one passive index fund to a slightly different passive index fund and believes he has made a strategic decision. He has not. He has made a random walk that costs him transaction fees and tax consequences without producing any directional advantage whatsoever. Real portfolio repositioning in a disruption cycle requires understanding which specific sectors benefit from the legal environment that has just been created, not just moving money around to feel busy. Stop being a victim, stop performing financial activity, and start executing financial strategy. The difference between those two things, compounded over the 18 to 36-month disruption cycle we are currently entering, is the difference between the winner and the loser. And the winner's playbook is specific, it is mathematical, and I am giving it to you right now. Here's exactly what you do. 5 steps. Specific numbers. No vague advice, no motivational generalities, no consult a financial advisor, disclaimers that let me off the hook without actually helping you. This is the framework. Execute it. Step 1. Run a full exposure audit within the next 48 hours, not next weekend, not after you finish this video and think about it for a few days. 48 hours. Open every account, 401k IRA, taxable brokerage, savings, and identify every holding that has direct or significant indirect exposure to the regulatory sphere affected by this ruling. Put a dollar figure on that exposure. If you cannot identify your exposure with specificity, you are managing your money blindfolded, and blindfolded money management in a disruption cycle is a guaranteed path to loss. Step 2, apply what I call the 15% repositioning threshold. If your exposure audit reveals that more than 15% of your total investable assets sits in sectors with elevated disruption risk, you are overexposed by the standards of disciplined risk management in a legal uncertainty cycle. The target is to bring that exposure below 10% through selective reallocation, not wholesale liquidation, which triggers unnecessary tax events, but targeted, deliberate trimming of the highest risk positions into sectors with structural tailwinds from the new legal environment. Step 3. Identify the 3 structural beneficiaries of this ruling and allocate toward them based on historical precedent from comparable legal disruption cycles, specifically post-Heller in 2008, post-McDonald in 2010, and the regulatory cascade following the 2016 election cycle. The 3 sectors that consistently outperform in the 18 months following a major constitutional ruling of this scope are diversified legal and compliance services companies, which see revenue expand during regulatory uncertainty, large cap insurance and financial services companies with the balance sheet strength to absorb repricing that crushes smaller competitors, and defense and security adjacent industries that benefit from both the political climate generated by the ruling and the direct regulatory changes it produces. These are not speculative positions. These are historically validated structural reallocations backed by 30 years of post-ruling market data. Step 4. Eliminate all cash holdings above your 3-month emergency reserve and deploy the surplus into the repositioned allocation immediately. Cash is trash in an environment where core inflation runs above the yield on any federally insured savings product. Cash is not a safe harbor. It is a slow tax on everything you have built. Your emergency fund stays liquid, full stop. Everything above that threshold is not safety money. It is opportunity money. And leaving opportunity money in a savings account during a period of structural market disruption is the financial equivalent of bringing a knife to a gunfight. Step 5. Set a hard review date 18 months from today and commit to it in writing. The disruption cycle I have described has a historical duration of 18 to 36 months. The first 18 months produce the most acute volatility and, correspondingly, the most significant wealth redistribution opportunities. Mark your calendar. At the 18-month review, you assess the positions, measure the performance against the repositioning thesis, and make the next set of decisions from a position of data rather than emotion. Winners make decisions on calendars, Losers make decisions on feelings. The numbers don't lie, and neither does the calendar. Execute these 5 steps, not in the order that feels most comfortable, not when you have more time. Now, the people who are going to be richer as a result of this ruling are already executing. The people who are going to be poorer are still deciding how they feel about it. So here's where we land. A 7-2 ruling, a nationwide legal firestorm, a $60 to $80 billion economic ecosystem in turbulence, an 18 to 36 month disruption cycle already underway, a 5-step mathematical repositioning framework sitting in your hands right now, today, at zero cost to you. I have given you everything you need. The only variable left is you. Are you going to be a winner or a loser? Are you going to audit your exposure in the next 48 hours? Or are you going to close this video, feel temporarily informed, and do absolutely nothing? The market already knows which one most people choose. It is priced into the spread between where wealth accumulates and where it evaporates. Subscribe to this channel, share this video with someone who is still sleeping, and leave a comment below with the first concrete action you are taking today. Not this week. Today. The firestorm is already burning. The only question is which side of it you are standing on. The American has approximately $102,000 sitting in accounts that are absorbing the volatility of a legal firestorm without a single defensive adjustment being made on their behalf. $102,000 bleeding quietly while you watch YouTube and feel whatever you feel about the politics of the ruling.